Ladies and gentlemen, once again, you're welcome to Diaspora Digital Media. We have a special guest this morning who will be discussing with us the state of the judiciary in the country, how we have fared so far, and most importantly, state of the nation from the eye of the judiciary. We have Barrister Ifeanyi Nrialike with us in the studio. Barrister, good day and welcome to the studio.
Thank you very much for having me.
Let's go straight to your office.
Yes.
Your slogan is "Judiciary is the last hope of the common man."
Yes.
Is our judiciary still the last hope of the common man?
Yes, judiciary is certainly the last hope of the common man. You know, without a judiciary, the system will be anarchic, and it will now be the fittest taking it. But because there is judiciary that is there, it will now help in resolving issues in a more civilized way without the use of brute force, but a system that is allowed for resolution where you say your own, the other person will say his own, and the court will make a decision. More often than not, you may not like the decision that is taken, but in every system, a decision must be taken at every particular point in time. So at any decision that is reached at the end of the day, you have to take it, whether you agree or you don't. So in everything, judiciary still remains the last hope of the common man. It is the best option that is available for us for now.
Fine. Granted.
Yes.
However, recent developments in Nigeria seem to have brought the judiciary into serious disrepute.
Yes.
Let's start with the recent All Eyes on the Judiciary. Nigerians stormed the streets, both the physical streets as well as the online streets.
Yes.
And they were chanting "All eyes on judiciary, all eyes on judiciary." Why do you think prompted Nigerians to take that stance if the judiciary is supposed to be their last hope?
All eyes on judiciary does not mean that the judiciary is not the last hope of the common man. All eyes on judiciary just means that everybody, the expectation is now on the judiciary. I was one of the greatest proponents of all eyes on judiciary. I even granted interviews on it, released press conference on it. It doesn't in any way remove the fact that judiciary remains the last hope of the common man. What we are just trying to say is that judiciary, we expect you to live up to expectation. Try as much as possible to live up to expectation. Give judgment according to law. Give judgment according to the facts and evidence presented before you by the parties in a matter. And at the end of the day, they did what they see as justice. You have a choice to agree or not to agree. But at that particular point that all eyes were on judiciary, all eyes were certainly on judiciary. And judiciary delivered.
That's what I wanted to ask.
Yeah.
Did the judiciary deliver?
The judiciary delivered because they delivered judgment. And not only that they delivered judgment. You know, in everything, some people will be crying, some people will be mourning. And they deliver judgment that made some people to be happy and others to not to be happy. Incidentally, they deliver judgment according to what they feel or what they saw. Because, you know, the truth about it is that at times, what we are seeing on the street may not actually be the correct position. You've seen that you may bring in sentiment.
You mean it is mob action?
No, you may bring in sentiment of the street. You may bring in, how do I say it? You may bring in sentiment. You may not be factual. You may not be a little bit some degree of rationality. You know, when they say that something not proved does not mean that it is not in existence. You may be saying this person snatched ballot box at this particular point. This person, the results were malfunctioned at that particular point, or that there were altering of results. But if you are not able to provide all the evidence that will help the court in reaching a decision, there is nothing the court will do. They will reach the decision on the basis of what they have before them. And more often than not, that is what happens. So, and when it happens like that, people will be shouting that this happened, that happened. But the question is, did you bring it to the attention of the court? Because you don't forget that these judges, these justices, they are human. And not only that they are human, they can't be everywhere at every time. At the end of the day, it is that complaint that you bring to them that are tied down in a bundle of documents, which we call evidence in law. That is what they will use to give their judgment. And at that point they are giving judgment, they are just impartial because that document, they call it documentary evidence, it doesn't lie. It doesn't speak any other language except the fact as contained therein and in a very permanent form.
I come again about on judiciary.
Yes.
I still have some reservations about judiciary. For example, one time Senator Adamu Bulkachua, who represented Bauchi North Senatorial District, once said that he used his wife's position as the then president of the Court of Appeal to grant favor. And when we hear favor in quote, we know what it means. To grant favor to his colleagues and fellow lawmakers. Does that not set off an alarm on the judiciary, especially when the Court of Appeal is involved, second to the highest organ of the judiciary?
The truth about it is that, yes, I remember that particular pronouncement that was made by Senator Adamu Bulkachua. But I can't remember him saying that he used it to grant favor to either his party members or to his friends.
Sir,
But
sorry to cut you short.
yeah.
That was his exact words at the National Assembly valedictory session.
Okay. Another thing is that when they are talking about favor, the question is that what sort of favor are we talking about?
Twerking judgments, verdicts to favor. Let us now break it down in our layman language.
Yes, it could have been entirely a different kettle of fish if he was
He faced a backlash not only from his fellow senators, but even from lawyers, from the media, from all sectors. And he stood by his words.
That is why I'm saying that if we were certain about the type of favor he was talking about, apart from that, if he was equally specific about who and who was this favor dispensed to, apart from that, the former President Court of Appeal came out clearly in a release press statement to say that every decision, every action she took while she was the President of Court of Appeal or in her entire life on the bench, that she was not influenced by anybody. And it becomes the word of one person against another. And at that particular time, we have to try as much as possible to be objective. For the fact that in law, they say who asserts must prove. And they having not been able to prove, you cannot just by the mere words of mouth. And in this particular time, what sort of favor are we talking about? So I had in as much as we know that a spouse will always have certain degree of influence over a husband or a wife may have over certain degree of influence over the wife. What sort of favor are we talking about? Is it influencing judgment? Or is it in helping to get a date? Is it in helping to make sure that the cases are promptly decided one way or the other? You know, that particular word as used by him was pregnant. and being pregnant, it is not for us to give it any sort of interpretation except a definite sentence or remark or pronouncement was made by the maker of that statement, exactly what it meant. Incidentally, the National Assembly, the presiding Senate president there didn't allow him to come.
Was even begging him off your bike. So, you're honorable, off your bike.
Yes.
It's okay, it's okay.
So for the fact that the Senate president, for the fact that the President Court of Appeal then was able to say in clear terms, my decision was not influenced. To a very large extent, I will go with that.
Fine, granted. However, for someone in that caliber, a serving senator then, to make such pronouncement, does that speak well of our judiciary? That is the matter at stake here. Not whether he said it was right or wrong, but for someone in that echelon of the society to make such a pronouncement against the second highest organ of the judiciary in the public sphere. What does that say about that?
The question you will ask yourself, does that speak well about Nigeria? It is not even a judiciary something. A judiciary cannot be taken in isolation. The issue is, does that speak well of Nigeria? But again, it comes in, that is where the indocility of the citizenry comes in. After that particular pronouncement was made, was there a follow-up, maybe a petition to the police, a petition to Economic and Financial Crimes Commission to investigate this crime? A petition to DSS to investigate this crime, because it is even a crime against state if actually something like that happened, and to what extent, and if at the end of the day these things were not investigated, did anybody approach the court to compel the investigative agencies to do investigation, maybe police and everything?
You know,
So these are the issues.
Some people, I can't remember exactly, but I know that either an individual or either a lawyer or a civil rights organization, civil society organization rather,
Yes.
petitioned the Supreme Court to take a second look at all the judgments passed by Justice Bolkatua.
That's why.
But I don't know the outcome.
They cannot take a second look at that particular. Once a decision has been delivered, a decision has been delivered, particularly by the Supreme Court. That could have been an effort.
It's not Supreme Court.
I know. That is what I mean. Any decision of Honorable Justice Bolkatua delivered, and most of them, or probably majority of them, go to Supreme Court. How are they going to review it?
But it's not
every
judgment that gets to the Supreme Court.
But
There are after post-election materials or cases that stops at the Court of Appeal. In that case, let me quickly bring in a second scenario.
Yes.
The one that recently now happened in Plateau State, where the Court of Appeal sacked the governor, Caleb Mutfwang, sacked all PDP lawmakers,
Yes.
and then the case of the PDP lawmakers stopped at the Court of Appeal.
Yes.
They lost out. The case of the governor proceeded to the Supreme Court, and the Supreme Court nullified that clause on which the Court of Appeal sacked all the PDP lawmakers.
Yes.
Now, and exonerated the governor. The governor is back, sitting in the office today, acting as the governor, but those lawmakers are out. In that case, what would they have done? They protested and they were told, hey, don't protest. They said, okay, we are coming back, seeing the Supreme Court. And the Supreme Court used very strong words to rebuke the Court of Appeal. At the end of the day, because this man's case got to the Supreme Court, he was exonerated and he's there as the governor today. Because the other people's case stops at the Court of Appeal, there are some who are now drinking kunu.
And anyway, the truth about it is that at every in, uh, in the course of litigation, a matter must end at a particular point. For the National Assembly, State House of Assemblies, election petition, it ends at the Court of Appeal. For the governorship and the presidential, it ends at the Supreme Court. Incidentally, we've seen situations where the Court of Appeal will see things from a particular prison, and when it gets to Supreme Court, they will see it from a different perspective. An example being the one that you just mentioned about Plateau State. It is just still recent.
Yes.
But again, that being the case, at that particular time, it will call for a sort of judicial reformation. Because as it is now, the Supreme Court for election petitions emanating from either National Assembly or State House of Assembly is the Court of Appeal. And every decision they take, it is not because they are infallible. Any decision they take is final. And just like they say, they are final not because they are infallible. They are infallible because they are final. Until they move to the next level, there is nothing anybody can do about it. It's just like it is not only the judgment of the Court of Appeal that have faced backlash from the public. Some judgments of the Supreme Court equally face backlash. But the truth about it is that, just like I said at the beginning of this program, at some point, some people will be happy about it. At another point, some people will not be happy. But that is the way it is. It's just like a football match. In every football match, particularly in the finals of a competition, a winner must emerge, either by the open play or during penalty kicks. And that is just it. At every point in time, what we keep on doing is keep on fine-tuning the system until we get a near-perfect system.
Now, I want you to tell us a little about the bar rather. Is the bar really living up to expectation? I will I will point out two prominent figures. One is a former president of the Nigerian Bar Association, and one is the present NBA president. The former NBA president, Dr. Olisabakova SN, during that All Eyes on the Judiciary campaign, lambasted Nigerians, lawyers, media, and even called the lawyers armchair lawyers. Say they should not come to the TV and make assertions over the revelations at the Chicago State University involving the educational qualifications of then Bola Ahmed Tinubu, the APC presidential candidate then, and later now the president. He said that lawyers should not come in the studio and start making assertions and start saying things they should not say over, especially over that Chicago State University affair. Was he right?
The truth is that that matter was then a live issue and before the court. And having posed that question to the court to answer, I think for every lawyer, by virtue of our training, you are expected to await the outcome of the decision of the court. For you to go and be saying Bola Tinubu's certificate was forged when it is being subjected, or it was being subjected to judicial inquiry. At a particular point in time, it is not proper.
But Abakoba himself has also taken positions in the past.
Yes.
For example, when the issue of 25% of FCT Abuja was in the court, he appeared on the TV and made his opinions known.
Yes, the opinion that he made at that particular time was equally to tell people to go and test this issue in court, because it will equally become a serious subject of litigation. And we knew that it became. to the extent that some Abuja indigenes and residents took the matter to court and clearly stated that 25% is a special clause in the Constitution. And any party, any candidate of a political party that fails to meet that requirement should not be declared president. We knew what happened in that case. And it equally became subject of litigation at the Court of Appeal and at the Supreme Court. What he was trying to say, if I am to say, is that lawyers, because the public takes serious our positions. When you come to the court and you say Tinubu forged certificate, and when you go again and you say the Chicago State documents from the certificates and results from Chicago State is not genuine, you are taking a position. And at the same time, another person will be shouting is genuine. So some persons who believes in one person that is saying that it is not genuine, and the others that are saying that it is genuine, may go out to the street and start canvassing that position without waiting eventually for the outcome of whatever decision the court will come up with. And these are the part of the things that we help, that we make it erode the confidence they have in the judiciary if at the end of the day the court takes a decision one way or the other. The next thing you will see people say, leave it. After all, the other lawyer said it was not genuine, and now the courts are saying it's genuine. Or leave it, the courts have said it's genuine, while the other lawyer is saying it's not genuine. Things like that. So that's why, because of organization, they are saying that those that are supposed to know should not go to TV and try to take a decision which will overheat the system, particularly if there is no definite judicial pronouncement on that aspect.